Good afternoon, friends. This is regarding Section 65 of the Insolvency and Bankruptcy Code 2016. As we are tracking this matter with regard to Amazon versus Bank of India, I am receiving certain queries like some investors are asking to help them with understanding on Section 65. It is just an academic effort, nothing to touch with the merits of the case, but just for the purpose of having certain awareness on this section, I thought I'll make a small video. Now, as you are aware, the Insolvency and Bankruptcy Code deals with the provisions relating to default and ensuring the company gets into a proper process of liquidation and resolution process. The whole thing involves a process of resolution, and if there is no scope, it will lead to closing down the company in general. Now, what is the Section 65? Section 65 deals with certain matters which involve insolvency related applications, and thereafter Section 65 deals with certain applications with regard to reference to the NCLT relating to the resolution process and liquidation process. Applications made under Section 7 or Section 9 of IBC. Now let's concentrate on Section 65, which reads, Section 65 reads, fraudulent or malicious initiation of proceedings. Subsection 1, if any person initiates the insolvency resolution process or liquidation proceedings fraudulently or with malicious intent for any purpose other than for the resolution of insolvency or liquidation, as the case may be, the adjudicating authority may impose upon such person a penalty which shall not be less than 1 lakh rupees but may extend to 1 crore rupees. Now we'll go to subsection 2. If any person initiates voluntary liquidation proceedings with the intent to defraud any person, the adjudicating authority may impose upon such person a penalty which shall not be less than 1 lakh rupees but may extend to 1 crore rupees. Now subsection 3. If any person initiates pre-packed insolvency resolution process fraudulently with malicious intent for any purpose other than for the resolution of insolvency or with the intent to defraud any person, the adjudicating authority may impose such a person a penalty which shall not be less than 1 lakh rupees but may extend to 1 crore rupees. Now let's examine the contents of the section and subsections relevant. The underlining is done by me. Let's understand what is the basic ingredient to attract these provisions. One is you need to have a proper basis if you are alleging that somebody has initiated proceedings against your company or some other company where you have interest with the sole intent of sending this whole company into liquidation. What is that intent? The malicious initiation of proceedings, fraudulent initiation of proceeding. These words fraudulent and malicious have to be proved in the court of law, that is before NCLT. Next is, if anyone initiates a proceeding with fraudulent intent and malicious intent for any purpose other than for the resolution of insolvency or liquidation. This is very important. Other than for the resolution of insolvency or liquidation, you have two clear goals under IBC. One is resolution or liquidation. The attempt of this entire process is to resolve the default, resolve the difficulty which is faced by the company by applying certain logic, certain methods by which if there is an opportunity to save the company, attempts can be made. But the point here is, if the intent is not to save the company, if the intent is not to resolve the insolvency or if the intent is not to liquidate the company, then these provisions are attracted. In all the three subsections, the penalty is very clear. It is 1 lakh rupees or it may extend to 1 crore rupees as the case may be. Subsection 2 is very clear. If any person initiates voluntary liquidation proceeding, again with intent to defraud any person, the adjudicating authority may impose upon such person a penalty which shall not be less than 1 lakh rupees but may extend to 1 crore rupees. Subsection 3, if any person initiates the pre-packed insolvency resolution process fraudulently or with malicious intent for any purpose other than for the resolution of insolvency or with intent to defraud any person, pre-packed, this is most important, pre-packed insolvency resolution process. If that is the case, and that too with fraudulent and malicious intent, if you are in a position to prove these points, then definitely strict action can be initiated under section 65 of IBC. Now this is all about the law. Now I would like to refer to certain latest judgments of National Company Law Tribunal, Delhi, wherein in case of Amit Katyal versus Meera Ahuja and another, which has been decided by the Honorable NCLAT, Delhi, on 9th November 2020. The bench headed by Venugopal M, VP Singh and Srisha Merla members. Here it's very important to note that the Honorable NCLAT has categorically held that initiation of proceedings under section 65 of IBC is not a provision to negate the proceedings under section 7 or section 9. Now I will take you all to a relevant paragraph which I have copy pasted in a separate document. This is the the content of section 65 related observation made by NCLAT in the said matter, where I have mentioned that I have copy pasted this particular section separately. Now the paragraph 46 of this judgment I'll read. It is not impertinent to mention that we often notice that despite fulfilling all requirements of section 7 and 9 of the code, petitions are rejected only on the pretext that a petition is filed for recovery of debt and not for resolution of insolvency. It is necessary to keep in mind that section 65 of the code is not meant to negate process under section 7 or 9 of the code. This portion is very, very important. It is necessary to keep in mind that section 65 of the code is not meant to negate the process of section 7 or section 9 of the code. Penal action under section 65 can be taken only when the provision of the code has been invoked fraudulently with malicious intent. Further, a reference has been given. The Honorable Supreme Court in Pioneer's case has given an instance of home buyer or allottee who does not have an interest in taking the possession and is only an investor. It has initiated the proceeding with malicious intent. The allottee does not want to go ahead with his obligation to take possession of the flat or allotment under RERA, but wants to jump ship and wants to get back the monies already paid by way of this coercive measure. This is very important. This coercive measure. In such cases, the use of section 65 is held justified because one home buyer, by misusing his position, could not stall the entire real estate project, but it does not mean that any insolvency application satisfying the requirements of section 7 or 9 of the I and B code could be dismissed arbitrarily under the guise of section 65 of the code, company appeal number 80 number 1380 of 2019 31 of 33. Here the point is, you can file an application under section 65, but your intention, your purpose and your sole object has to be very clear. If you are not intending to resolve the matter, if you are not intending to ensure the company goes into liquidation and your purpose is something else, then section 65 cannot be used merely for the purpose of ensuring the dismissal of the section 7 petition. So here I just made an attempt to take this particular audience through section 65 and related case law. Now the same case, Amit Katyal versus Meera Ahuja, this matter went up to Supreme Court thereafter. Now here Honorable Supreme Court, I'll just take you through the in this matter, which is a reportable judgment, the Honorable Supreme Court in Civil Appeal number 3778 of 2020, this matter finally came to be settled. Therefore, here also it has been held that the findings of NCLAT with regard to section 7 and section 9, so the audience, the investors or law students and practitioners are requested to refer this particular case law, which has travelled from NCLT till Supreme Court, and the matter was allowed to be settled, and finally a cost of rupees 6 lakh has been awarded, which was a sort of a cost incurred by the resolution professional in contesting this whole matter, and even rupees 6 lakh has been awarded by way of cost. Here it is there in para number 16. To do the complete justice in the matter, and considering the fact that after the admission of the CIRP proceedings, IRP, that is interim resolution professional, was appointed and COC was constituted by IRP, and it is reported by the IRP that he had incurred some expenditure, we direct the appellant to pay a sum of rupees 6 lakh rupees to the IRP to be paid towards the expenditure that might have been incurred by the IRP, and also litigation costs which shall be paid to the IRP by way of demand draft within a period of 2 weeks from today. So therefore, a small attempt I have made here to educate on section 65. This is just a educational video for the benefit of the members who are in touch with me with regard to the concerned matter. This is not at all touching any of the contents of any of the matter which is sub judice before either NCLT, NCLAT or any of the courts time being. Thank you very much.